The Holocaust Expropriated Art Recovery Act, or the HERE Act as it's known, was passed in the final days of the Obama administration upon overwhelming, I think maybe near unanimous congressional support. And the purpose of the statute is really to try to embrace what has been a public policy in this country for decades, namely that it's the policy of this country that property, and in particular artwork, that was looted by the Nazis during World War II from Jewish families should be restituted to those families, to their successors. And that has been something that the country has espoused in certain declarations over the years, but has never, prior to the HERE Act, passed a law that makes that the substantive law of the country. The HERE Act doesn't do that either. The HERE Act recites the policies as a motivation for its enactment, but what the HERE Act does is it takes laws around the nation from all the various states. For instance, any kind of claim that would be used to recover what is alleged to be stolen property, and applies a nationwide statute of limitations over all of those claims throughout the country. So cases involving Nazi looted art involve a number of, I think, fairly unique challenges for both sides. But when you deal with cases of alleged Nazi looted art, you're dealing with the passage of decades of time. And so what you're fundamentally dealing with in most cases is a loss of witnesses who could personally attest to what had occurred, and very often the loss or destruction of documents as well. And really what you're talking about is a loss of evidence. And so that's a challenge for both sides. One of the things I find so, sort of emotionally and academically interesting about these claims is that they very often pit two sympathetic parties against one another. You've got somebody claiming to have been victimized by Nazis, and then you've got a good faith possessor who paid value, who is being told that if the work was stolen, then you have to give it back. And very often it's for no refund or well beyond a limitations period against the seller of the work. And so you're just out if you're the good faith possessor. And so you've got two sympathetic parties. And then the law has to come in and really assign between those parties, who should bear the risk of loss, who should bear burdens of diligence, and ultimately who should prevail. My article explored a constitutional problem with the HERE Act, which is to say a problem based on a doctrine called preemption. It's well established that the federal government has the power and the right to come in and legislate fields of law if it believes appropriate. And the HERE Act is a preemptive statute. It legislates the area of statute of limitations in these particular kinds of claims involving Nazi looted art. The problem, though, is that preemption historically is based on the federal government coming in and creating a federal substantive cause of action. And that's not what the HERE Act does. The HERE Act basically engrafts its own procedural statute of limitations on pre-existing substantive causes of action created by the states. And that is a problem because there's no precedent for the federal government being allowed to come in and just put on its procedural preferences onto all state laws. And so my article explores in some depth what are the arguments for and against that kind of exercise of power by the Congress, and ultimately my conclusion is that Congress does not have that power under the 10th Amendment to the Constitution, which is basically a principle of federalism. So I think that good faith owners of allegedly looted art, Nazi art in particular, need to really first and foremost give thought to whether the evidence that's available does demonstrate Nazi theft. I think not only from a legal perspective, but from a moral perspective, those parties should give serious thought to whether they have an obligation to restitute what really would appear to be stolen property back to the victim or the victim's surviving family. That said, there are claims out there that are asserted and not predicated on particularly strong evidence. And we are still, the court system is still driven by an analysis of evidence. And so if you find yourself in a situation where a claim is being made against you, and the claim appears to be fairly conclusory and not rooted in testimony or documents or other objective evidence, then I think that the good faith owner needs to give serious consideration to whether there is a defense that I would consider to be basically a due process defense, whether that is rooted in the laches doctrine or in a statute of limitations that might apply. Both of those are really about, look, there's just not enough surviving evidence. The claim is really too stale and unfair for me to meaningfully prosecute or defend, and that might be a consideration that warrants putting on a defense and litigating.